Is it? Good evening. I'm Marty Mix, President of the Golden Valley League of Women Voters, and I want to, on behalf of the Golden Valley League, the Wayzata Plymouth League, and the Minneapolis League, want to welcome you here tonight, and thank you for coming, and thank you for watching from home. Now, the League of Women Voters is a nonpartisan organization of both men and women. We do not endorse or support candidates or political parties. The reason we sponsor candidate forums is to provide voters with the information they need to make informed election decisions. All of the candidates were invited and are here tonight, and it is our goal to treat each candidate with fairness and courtesy. The views expressed by the candidates are theirs alone. Now, as a bit of background, tonight's forum is for the 4th Judicial District, seat 22. Our state is divided into 10 judicial districts, of which the largest one is the 4th, and it covers all of Hennepin County. With 62 judges in the 4th District, 12 referees, and 549 staff members, the 4th District handles nearly 800,000 cases a year. Nearly all judges are first appointed to fill a vacancy with advice from a commission on judicial selection. However, in this case, seat 22 is an open seat, meaning that none of the candidates are incumbents. The term is for 6 years, and the salary for a judge is approximately $129,000. To be eligible for a judgeship, one must be a lawyer admitted to practice before the Minnesota Supreme Court. And I would now like to introduce Kay McCulley, who does not live in the 4th Judicial District, so we can have a very fair forum. Thank you, Kay.
Thank you. The purpose of this evening's forum is to bring candidates face-to-face with each other, and particularly with those people in the audience and with those who will be watching on cable TV. The questions asked of these candidates are different from what you might get at a forum for other kinds of candidates other than judicial candidates, because you cannot ask questions that have to do with specific cases. You cannot ask questions that are cases that might come before a judge. So when you're doing questions in the audience, you'll keep that in mind. We do have 4 candidates for this seat, and I will just say their names, and we'll repeat them often, because we want you to know and recognize when you get to the ballot who belongs to what name. So on the far side is Stephen Antolak, Elizabeth Cutter, Diane Krenz, and Deborah Russell. We do have some guidelines for the forum tonight. We will start with an introductory question, and each candidate will have 1.5 minutes to answer it. We do have a timer sitting in front. When that's 15 seconds left, you'll receive a sign. When your time is up, there'll be a stop sign. If you're in the middle of a sentence, you can finish the sentence, a short sentence. Next, after that, will be a question and answer period in which the audience is encouraged to submit questions. Some people have already done that. They will be collected by league members. Just hold up the card and somebody will come and collect it. They'll be brought up to me, and we will review the questions. And if there are questions that are similar, we'll put them together to make one question out of this so we can get as many questions as possible. After that portion, there will be a closing statement where you will have up to 1 minute to say whatever is left that you just haven't had a chance to be able to talk about during the evening. In a forum such as this, there will be no reference of a personal nature. A person's public record may be examined, but not their character. Before the forum started tonight, the candidates drew numbers to decide what order they would go in, and so I have that list. They know which turn they're going to take, and when we get to the regular questions, we will go in alphabetical order. And we'll begin with the first question, which is, why are you running for judge, and what are your qualifications? And Deborah Russell is number 1.
Thank you. I am running for judge because I see it as a natural extension of my service in public in the public sector for almost 20 years. I have been an advocate for almost all of those 20 years. I have represented the Department of Children and Family Services in child protection matters. I have represented criminals that have been charged with misdemeanors and felonies. I have prosecuted juvenile delinquents, and I have prosecuted adult violent felons. And throughout the course of my career, I have been an advocate. And I would say over the last 5 years or so, I have begun to widen my perspective a little bit as far as what is an appropriate disposition for a case. And in doing so, I have to look a little bit beyond my own narrow perspective and see what other perspectives are brought to the table. Because to me, a fair and impartial judge looks at all sides of a case. And for me, I have seen that the public is very interested in a fair and unbiased criminal justice system. And I think that it's important, these qualifications that I have based on representing the Department of Children and Family Services in child protection matters, as well as defending cases, I bring both sides to the table and can offer both perspectives. And that's what I would offer if I were voted as a judge.
Next candidate is Stephen Antolak.
Good evening. I've been a lawyer conducting trials and contested hearings for almost 30 years. I've practiced in many jurisdictions and many different courts in 8 different states. So this has given me great breadth of experience on the substance of the law, but I've also received a broad experience in the way procedures are used by these courts and judges to administer the law. I believe in service to our community. I volunteered for the Human Rights Commission and Planning Commission in Brooklyn Park. I've been in a number of county and local citizen task forces. I volunteer as a law day presenter, a high school moot court coach, Boy Scout leader. And I grew up as the son of immigrants to this country, working with groups, immigrant groups, service clubs, and diverse groups. I understand the role of diversity in a healthy society. Public service has prepared me to be a district court judge. Volunteering in the community has brought me closer to others in need and developed greater capacity for compassion. Service has taught me the importance of patience and humility. It has fed a natural hunger for justice and equity. My service as a judge would reflect these values. Now, I was also elected to the District 279 School Board and served on the Intermediate 287 School Board. That gives me a unique perspective in how decisions are made publicly. Because on the school board, you take evidence publicly, you debate the matter publicly, you answer publicly. That's what judges do. I've developed wisdom and compassion. I'm a man of integrity. I will bring these things to the judgeship in Hennepin County. Thank you.
Next candidate is Elizabeth Cutter.
Thank you. I have been a trial lawyer, both a civil and a criminal trial lawyer, for over 30 years. I have been in public service all of my career. I went to law school to become a public servant. I have handled cases throughout the state of Minnesota. I was with the Minnesota Attorney General's office, and now I'm with the Hennepin County Attorney's office. I have appeared before good judges, and I've appeared before judges who were not as good, and I know the difference. And I believe that my characteristics and my qualifications would make me a good judge. I am a supervisor in the Hennepin County Attorney's Office, so I have management experience. In 2010, 2011, I was invited to participate in the Management Institute, which was a year-long course that gave me a very broad view of the work that is done by Hennepin County. The course was helpful in developing leadership skills as well as management skills. I also sit on a number of community boards and commissions, as well as commissions involved with my work. I'm on the Fatality Review Board. I'm on the Family Violence Coordinating Council. I'm on the Domestic Violence Steering Committee. I'm in the prosecutor who's in charge of felony domestic violence prosecution. All of those leadership and community service activities have taught me what goes on in Hennepin County, who's involved in Hennepin County. I also enjoy the support of many of the leaders in the legal community as well as the community at large.
Thank you. Diane Krenz.
Thank you. I'm running for judge because our courts need judges who can immediately begin working in the courtroom, We need judges who know the rules of evidence, who know courtroom procedures, and who know the law. We need judges who have tried cases, and I have that experience. I have tried over 75 felony jury trials. I have worked in our office, the Hennepin County Attorney's Office, for 29 years, which includes all my law clerk time. I've been a prosecutor during that entire time. I have tried rape cases. I have tried murder cases. I have tried every kind of assault, burglaries, identity theft. I have tried numerous kinds of cases, including gang prosecution. And I have done felon in possession gun prosecution. That was my assignment for over a year. I have more trial experience than Michelin has retreads. So I have the experience to immediately step on the bench and try cases, and that's what Hennepin County needs. The majority of cases that go to trial in Hennepin County are criminal cases, and we need somebody who can do that work, and I have that experience.
Now we'll move on to questions that have come from the audience and other questions that have been collected in other ways. And you'll have 1 minute. We give you these hard questions, and in 1 minute you're supposed to solve them, of course. And we will go in alphabetical order, but we will rotate with each one. And one of the questions actually came from a couple of people that a lot of you have answered. And I'm just going to toss that out and see if there's anything else you didn't say or want to add to it. I don't want you to repeat what you've already done. Why does community involvement enhance your work as a judge? How have you been involved in the community? I know a lot of you have already discussed that. And what should voters take into consideration that has to do with those activities? How would it affect how they choose who they want to vote for? Stephen.
Well, I've been involved in a lot of different community activities, and I would like to point out that those community activities were outside of my profession. They're ways that I came in touch with members of the community, people who live every day around us, who may not necessarily see us at work or in the job. I think that's particularly important because it's those connections, that understanding of what it is to be a human being in our society, understanding that compassion, understanding and being able to take people where they are at. Because if you're going to do any sort of judging or any sort of work to deal with these people, you need to know where they are, you need to accept them where they are, and you need to work compassionately with them. I think that's probably the most important feature of being a judge, is having that gift of compassion. Because wisdom without compassion is nothing. That's what community service does for you.
Elizabeth Cutter.
Like Mr. Antolak, much of my community service is not related directly to my job. I sit on a number of boards and commissions outside of the legal field, including Interact, which is an organization that provides opportunities in performing in visual arts for adults with mental disabilities, or Minnesota Comprehensive Health Association, which is the state risk pool for high-risk individuals who aren't able to access health insurance through the regular market. So I have a number of experiences throughout my career, and I invite you to go to my website, which is www.cutter4judge.com, where all of the community services listed. I have a lifelong service to the community. You learn the community that you will serve as a judge. Also, when you are called upon as a judge to solve a problem that requires community input, I know the leaders in the community. Those leaders are listed as my endorsers. I know those people. I can call on them to help solve community problems.
Diane Krenz.
Well, I, like everybody else, I'm sure on the panel, have had lots of community experience. I volunteer on the Special Education Advisory Council for the Minnetonka schools because my child has special needs. Until we had our daughter, worked for over 1,000 hours at a thrift store that benefits the developmentally disabled. So essentially selling things to support people that were living in group homes and places like that. So I've had a variety of community experience. And like everyone says, I think it gives you the compassion to understand people. it also gives you the people skills, for me especially, the people skills of meeting people in the community, helping somebody, giving input to a particular process, and again, it shows a commitment to the people of Hennepin County.
Deborah Russell.
Like everyone has said, being a member of the community and active in your community is important because it helps you to develop the respect for the members of this community. And as a judge, you are asked to make decisions revolving sometimes community issues, whether they are civil or criminal. And my community involvement has stemmed back all the way to Children's Home Society, where I was a volunteer for fundraising for them. I've also volunteered for Retrieve a Golden of Minnesota. My passion outside of my work is with dogs and training dogs, and I've made so many wonderful connections through dog competition, training events, and again, as Mr. Antolak said, those are people that aren't in the halls of the courthouse. Those are people that are living lives very different from my own, and it's exciting and invigorating to get out and interact with everybody, and I think it does. It helps with compassion and it helps with respect.
Thank you. Since this forum is to help people who are watching this decide who they want to vote for, if you were on the other side watching this, what kind of criteria do you think the voters should use to evaluate a judicial candidate? Elizabeth Cutter.
All right. I think that there are a number of characteristics that would mark a good judge. I think that a good judge is respectful. A good judge is a good listener. A good judge is prepared, timely. Underneath all of those characteristics is ultimately fairness. A good judge is fair. Studies have shown that when litigants when they're appearing before a judge, if they believe they were heard, even if the decision is against them, they believe it was a fair decision. So all of those characteristics are important, and those are characteristics that a prosecutor needs to have too. A good prosecutor is someone who's respectful. A good prosecutor is someone who listens. A good prosecutor is prepared, is timely, and listens to the different people who are involved in the case. So those are characteristics I have had as a prosecutor. I believe those are characteristics I would bring to the bench.
Diane Krenz.
I think the voters need to look at a person's experience. I think they need to find out what the person's people skills are, how they relate to people, how they have good judgment. It's kind of hard to find out that sort of thing, but you can always contact people to find out, what do you know about this person? And that's, frankly, I think how we make most of our decisions when it comes to voting in any election. I think that people should look for a lack of politics involved in somebody's judicial campaign or their we don't want political judges, and I think that that's something people should really look at as well. So I think that, again, judgment, experience, lack of politics, and people skills.
Deborah Russell.
I think fairness is probably the most important quality that an incoming judge should have, that voters should be able to see. And what I mean by that is an ability to see different perspectives of a same situation, because you will always, as a judge, have people coming in with differing opinions, differing perspectives of things. And as a judge, you have to be able to see and understand all of those different perspectives and then be able to wade through those and come up with a decision that's fair. And I think what most people are looking for in a judge is someone who is unbiased, someone who is going to treat people, as has been said previously, respectfully, to listen to people and make sure that their arguments, their advocating is being heard. But ultimately, the reputation should be that for someone who is being fair, someone who can see and listen to all perspectives that are brought before that person.
Stephen Antolak.
Sitting up here, we've got more than 100 years of experience in doing trials. The rules of evidence, the rules of procedure aren't going to be an issue with us. We've all had success in our various areas of our careers. So I would suggest the thing to look at is, what are those careers? what kind of experience would each of us bring to the bench? Right? What can we bring from outside Hennepin County, from what outside is already something that's not there yet? What can we do to improve Hennepin County? What can we do to demonstrate that we understand people who are not just the county or just the people who get called into regular litigation just in Hennepin County? I've got that experience. I've dealt with private parties for the last 20-some years. I would suggest you look at our careers, look at what we've done in the past, and let that inform you as to exactly what each of us can bring that's different to the bench.
Thank you. Next question. This question is obviously assuming that you have what this is asking about. Who are your judicial role models, and why would you choose a particular person? And we'll start with Diane Krenz.
Well, how do we answer that question without putting some sort of, without offending anybody, I guess? I guess the judicial role models that I have are the people who are willing to listen to both sides, the people who don't get involved in negotiations between the parties inappropriately, judges who have a good sense of decorum in the courtroom, who don't, let's say, talk about other people behind their back sort of thing. I think that the other judges that I appreciate are, are serious about the system and don't make the system a laughing stock, and understand what the issues are that are brought before them and listen fairly and make a decision based on the evidence.
And you can name, I mean, if you choose to, and I understand.
We have to work again.
And Deborah Russell.
Thank you. One thing that I admire in many of the judges that I appear in front of is their ability to make a decision. I think there has to be a little element of fearlessness, because oftentimes there are people that come before you that are fighting like cats and dogs, and as a judge, you need to be able to step up and make that decision. And I know I'm going to embarrass him because he's here tonight, but Judge Dan Mabley is actually a role model of mine and has been, but really did in the trial of the year, State versus Amy Sensor. Judge Mabley was under the hot light, as we all were, where the public was paying very, very close attention to this case. And every decision he made, every step he took was under intense scrutiny. And what I admired was his courage in making his decisions, in articulating his decisions, and I felt he gave both Ms. Sensor and the state a fair trial in this case. And those are all the qualities that I look for in a judge.
Stephen Antolak.
This is a tough one. I'll tell you that from my experience in Hennepin County, there are a lot of really fine trial judges there. I really like practicing in Hennepin County. And I really love the idea that I would join those judges as compatriots. So I'm going to take a look at and do the question a little differently and say, who wouldn't I want as a judge? and I'll point that out, I would say, like Judge Judy and some of those people on TV. Because those are personality cults. They're not about justice. They're not about fairness. If I'm on the bench, it's not going to be about me. It's going to be about serving the public and doing what needs to be done right.
Elizabeth Cutter.
As I said, I've appeared before a number of judges, both state and federal, and trial and appellate. And the ones who are well prepared, the ones who are respectful to the litigants and to the parties that they represent, the ones who recognize that even though it might be a small case or an insignificant case in the grand scheme of things, it is the case that that litigant has and shows the deference and the respect to that case. Those are the judges whose respect I want and for whom I give respect. And also those judges are decisive. You know, they are prepared, they know what the facts are, they know what the law is, and they make a decision. As I said before, litigants want decisiveness in their judges. They would rather almost have a decision against them than an indecisive period with a judge. So I think that a judge who is respectful, fair, prepared, and decisive.
Do you think that judges have an obligation in this role to improve public understanding of the courts? If you think so, how would they carry out an obligation like that? We'll start that one with Deborah Russell.
That is quite a question. It's hard to say. I think the obligation comes in conducting oneself to the best of one's ability, and I think that you improve the public view of the judicial system by carrying out your activities as a judge in, as we have already said, a respectful, fair, decisive manner. I don't know how judges can actually go out and improve the public perception. Again, when you have some of these trials that make the media and people are paying attention, I do think it makes a difference if a judge is being decisive and is being articulate as far as the rulings are and the treatment of the litigants. So whether it is an obligation, I think every judge should strive to have the perception be that this person is fair and respectful of all who come before him or her.
Thank you. Stephen Antolak.
Yes, I think absolutely judges have that obligation, and I think this is actually an access to justice issue. Most of the time when we talk about access to justice, we're talking about public defenders or appointed counsel, but it's actually much more than that. We need to provide timely hearings for people. We need to make sure that their cases are resolved promptly. We need to simplify some of the complex legal entanglements so that people can make a judgment as to whether or not they should be representing themselves. Those are the kinds of things that give access to justice, that bring people forward, that improve the quality of justice within our system. And the ways to do that are numerous. I mean, there's all kinds of technologies that are used in the business world. We just need to start doing them in government. We need to start doing them in the justice system to make that happen.
Elizabeth Cutter.
And I agree with Mr. Antolak that absolutely judges have an obligation to educate the public about their judicial system, and many judges do that. I was president of Minnesota Women Lawyers in 2010, 2011. There are many judges who are involved in that organization who, through their work in that organization, serving on different committees, were able to educate the public about the role of judges and the courts in their lives. I'm active in the state bar and in the local bar. In both of those, judges are very active in helping to educate the public about the judicial system. Justice Gilday has spoken to a number of groups about access to justice, about the importance of funding legal services. There are 40% of the litigants who appear in family court are self-represented. That is one of the messages that Justice Gilday brought home to the public, not just to the bar, but to the public in her public speaking. So judges do have a role that doesn't interfere with their judicial independence to educate the public about the court system and making it transparent and accessible.
Diane Krenz.
Thank you. I agree. I think judges do have an obligation. I do know that the Supreme Court and I believe some of the Court of Appeals justices go around and talk to school groups. I think that that's a very basic thing. I agree with Mr. Antolak about access, but I think it is important for judges also to go into schools, as I said, and to talk to kids and explain the system to them. I don't think kids are always getting as much information in civics lessons anymore about what the judicial system's about. And I think that's a pretty basic thing that judges do, and I know that there are a number of them that already do. I know that some of the judges on the Hennepin County bench will invite high school students in. So I think that judges do have an obligation. I think they're fulfilling it. I think, like Steve says, there's probably more that can be done, though.
Okay, thank you. The next question, since you are all new to a judge position, there's no incumbent here, so this question will fit everybody. What problems might you encounter do you think, for yourself as you move from your role as an advocate or a prosecutor or whatever your current position is to the role of a judge? And we'll start back with Steve Antolak.
Oh, I don't see too many problems coming up in my practice. In private practice, you have to have continuity plans. You have to plan for accidents, things that happen to your practice. So my clients and my referrers are going to be peeling off between now and January anyway, because it's pretty hard to say that you might not be around in January, so you should hire me. So I'm not going to have those kinds of problems. I think that conflicts will be few and far between for someone who has a solo practice like I do outside of the court system. So I really don't see many issues, many problems. It has been some years since I've clerked for Judge Mabley and others, so I may have to refresh myself on some of the standards that apply to enforcement of rights and some of the things that happen in a Rasmussen hearing and some of the things that happen in procedures. But I think overall, I'm going to be ready to step in exactly where the chief judge needs me.
Elizabeth Cutter.
Well, I think that there's a shift that you would have to take place from being an advocate to being a neutral fact finder or calling the balls and strikes in a trial. And I think that will take some adjustment. I've been an advocate for over 30 years. However, I think a sign that I can do it is that I have for over 20 years sat on the Enrollee Appeals Committee for the Minnesota Comprehensive Health Association. And in that role, what I do is I decide appeals that are made by enrollees, by prospective members and members of Minnesota Comprehensive Health Association regarding health care benefits. They appeal decisions from the insurance company to our appeal committee, and we make that decision. The committee is made up of members of MCHA, public members, of which I'm one, and industry members. If I was not being fair and impartial, I would not have that position as a volunteer.
Diane Krenz.
Thank you. Frankly, I think it would also be tough to switch from being an advocate, but frankly, I think it would be tough to have my friends in the court system appear in front of me. I have lots of friends in the county attorney's office. I have lots of friends in the public defender's office. I have lots of friends who are in the civil or the criminal defense. And I think actually that would probably be very hard. I would have to set aside some of the feelings I have about my friendships with people or my knowledge of some of these people and listen to their cases. Now, I believe I can do it, but I think that would be a hurdle that I'd have to jump over.
Deborah Russell.
The three of us being in the county attorney's office all come in as prosecutors, and the question is, how do you transition from being a prosecutor to being a neutral fact finder? And one of the things as I was contemplating seeking out a judicial spot was talking with opposing counsel and defense lawyers that I have worked against over the years. And what was extremely gratifying to me was to hear their unanimous support of me going after being a judge, because even people that have gone against me in litigation felt that I had the temperament and the personality and the qualifications to be fair. So I am happy to say that I don't think the transition will necessarily be too difficult for me, because I'm already seeing things from another perspective, and I have the support of those that have opposed me in various litigations.
Some of the next questions are going to be a little more, I would say, nitty-gritty about the actual job of doing the job of being a judge. What criteria would you use for deciding whether to impose or affirm sentences outside of a standard range? Let's start with Elizabeth Cutter on this one.
Well, luckily we have guidance. There are the sentencing guidelines provide criteria that can be used. There are also a number of appellate court decisions. And in my own experience as a prosecutor, I have seen cases that do deserve more than what the guidelines and cases that deserve less than the guidelines. As a supervisor, I give authority to the lawyers I supervise. to depart from the guidelines, to give an offer of a lesser sentence. So these are criteria that I'm very accustomed to weighing. And without having a specific case in front of you, it's hard to say what those are, but the guidelines set forth criteria that can be used.
Diane Krenz.
Well, I agree with Liz. I mean, there are very specific criteria that you can and can't use. I mean, one of the things I would really shy away from is negotiating cases. Judges are not allowed to do that, to say, well, I'm going to give this guy something less than what the guidelines are, and when the prosecutor doesn't agree. That's one thing I would not be willing to do. Again, just like, Deborah and Liz, being a prosecutor, we weigh our cases all the time. We weigh our cases when we decide to charge them. What am I going to charge the person with, and what am I going to settle it for? And so I think of my 20, almost 30 years of experience of doing that, I know what a case is worth and would listen to the arguments of both sides and make my decision.
Deborah Russell.
Thank you. As my fellow prosecutors, I also do have this experience having seen cases that were sentenced within the guidelines range and then cases that have been sentenced outside of the guidelines range. And I believe that experience is valuable in my ability to evaluate a case. Every case is different. That's one thing I've learned after all my years in the criminal justice system. There are no two cases that are exactly alike. There is always something different, whether it's about the offender or whether it's about the victim or any other aspect of the case. And so the guidelines are there as guidelines, and they give you what the presumptive sentence ought to be. But I do think it's important to look at each case individually and see what differences there might be there. And if there are substantial and compelling reasons to go beyond those guidelines, I would not hesitate to do so.
Stephen Antolak.
There are three things to consider. Minnesota has sentencing guidelines that establishes ranges for incarceration and probation for people who are convicted. So you got to stay within those guidelines, number one. Number two, every convicted felon and most other misdemeanors go through a pre-sentence investigation. There's all kinds of resources that come together at sentencing to inform the judge as to what can be a disposition for this case. And the last thing is to remember that we have an adversary system. We have an advocate in the prosecutor, we have an advocate in the defense attorney. They look at the guidelines, they look at the cases, and they make their best pitch to the judge on exactly what should happen in sentencing. So there's a wonderful collection of information that a judge can look at and determine how to move forward. I would do my best to follow that and to stay consistent with the sense of what we do in Hennepin County, with the sense of what we think is the right thing to do in Minnesota.
The next one actually has two parts. If it gets too long and I need to repeat it, I'll be glad to do that. As a judge, if you had become aware of unethical conduct on the part of a trial advocate in a case in which you were presiding, how would you handle it? And follow up to that, do you believe that judges should be required to report attorney misconduct? Actually, I guess those are really two separate ones, aren't they? Do we want to repeat it? I'm going to lead them in together anyway. And the first one.
Am I going first?
No,
Oh.
Diane Krenz is first.
You were looking at me, and I thought that I had to come up with an answer here.
That's okay.
I think judges are required to report unethical conduct. I have to confess, I probably have not read the Judicial Code of Conduct recently, but I do think that if an advocate or a party in a case is engaging in unethical conduct and it fits within the parameters of what's proscribed, what you cannot do, the thing I always took away from lawyers' responsibility, which was the ethics class they taught us, was rat on your friends and be available to testify. That's what they told everybody. And so I think a judge has the same obligation. We don't, the law profession is self-policing as well. And so if judges don't report it and if lawyers don't report it, unethical lawyers continue to practice.
Deborah Russell.
So much of our world is based on reputation. When you appear before a judge, your reputation comes before you, and the longer you practice, the greater the reputation you have. And I do believe, I agree with Diane, that there would be no sense in a judge turning a blind eye to unethical conduct. And like Diane, I have not reviewed the Judicial Code of Conduct, so I'm not exactly sure what would be expected of judges. But I don't see any reason why a judge would not and should not report unethical conduct. Again, the numbers of trial lawyers are limited in Hennepin County. We encounter the same people again and again, and people's reputation means everything. And again, I think that a judge should be involved if there is documented unethical conduct. I think a judge does have the obligation to report it.
Stephen Antolak.
You know, there are all kinds of myths and truisms about litigation, and one of the truisms is that it's a contact sport. And, you know, we're all advocates, and we're all pushing very hard on very controversial issues. People are injured, people are hurting, people are harmed, and we're trying to get at the truth, we're trying to get at justice. And so a lot of times, attorneys push pretty hard. So the first thing the judge needs to do is to find out, look, is this really an ethical violation? Is this something that got carried away? Is it something we need to deal with? And if it's intentional, if it's volitional, if we're causing harm intentionally in violation of the rules, absolutely the judge needs to do something about it. And in Minnesota, we're pretty good about it. We do prompt investigations. We have a 4th Judicial District committee, bar committee, that investigates these. I'll tell you, I've traveled throughout the states, and there are a lot of places where it's not much fun practicing because judges are afraid to do those kinds of things. I love coming to Minnesota because we police ourselves well. The judges here, the attorneys here are well behaved, and it happens because judges have the courage to do that.
Elizabeth Cover.
I do believe judges have the obligation under the code to report acts of unethical behavior that they are aware of. And I know that for a fact because I sit on the District Ethics Committee for the Hennepin County Bar Association, and I have handled investigations of complaints filed by judges against lawyers practicing before them. And so it's an obligation that we have. It's part of keeping the profession honorable. It's part of public confidence, not only in the lawyers who appear, but also in the bench, so that the public is aware that the bench will be policing the lawyers who appear before them. And it does happen, and they do have that responsibility under the code, just as lawyers have the responsibility under the code to report unethical behavior.
Thank you. I'm referring back to Marty's introduction when she was describing the 4th Judicial District handling 800,000 cases of even from small to large in a year. I think the next question is pretty appropriate with numbers like that. Do you have methods to suggest for improving court procedures and efficiency? Start with Deborah Russell.
Well, I am happy to report that I am a very efficient individual myself, and so I do think that if I were elected to the bench, I would handle my caseload very efficiently, and we need judges like that to be efficient with cases. And part of it is knowing the value of a case and knowing how cases can be settled. You don't certainly want to undercut any of the litigants, but a lot of time is spent on unnecessary chit-chat, if you will, or just passing the time. There's also the issue of lawyers having to be in more than one place at one time. And I think we're working on scheduling for at least the prosecutors, where they put us all supposedly in front of one judge or one group of judges. But I think that's got to be done for the defense attorneys as well, because they are in different places and oftentimes are not accountable. And I think if I were as part of the bench, I would want some more accountability from the defense bar.
Stephen Antolak.
You know, I guess I'm probably one of those guys who always think the judge is too slow on my case. So, you know, I would want to walk a mile in those shoes before I criticize that. But I think there are a lot of things that we can do as a system to try and improve it. You know, the business world uses call centers. It uses online scheduling. It uses calendar systems. It uses paperless transactions, different kinds of online collaboration. There are all kinds of wonderful tools out there that can be used to try and speed this along, to get rid of some of that fluff, to kind of squeeze things down and take advantage of the time that we have. We've got a lot of talent in the system. Everybody's time is valuable. And so we need to find these tools, these technological tools, these business tools that are very common that can make use of everybody's time and keep everybody treated fairly. I think there are ways to do it, and I think we just need to get a little creative about it.
Elizabeth Cutter.
Well, Hennepin County is known nationwide as an innovative court system. We have one of the most innovative judicial systems that in the country, and other districts look to Hennepin County for the innovations. And among those, we are going to e-filing so that we'll have a paperless court system. That is going to save a lot of time. We also have accessibility to records that a judge needs regarding a particular case immediately. That has saved time. There have been a lot of technological advances that Hennepin County has taken advantage of over the past 10 years that have helped streamline the system. I mentioned earlier that that there are an increasing number of self-represented individuals in Hennepin County, and Hennepin has a help center where they have very experienced lawyers helping those people to help them sort out what the issues are, and they're helping the system to go more smoothly and quickly.
Diane Krenz.
Thank you. I think that one of the things Hennepin County has been also doing is blocking cases. I think Debbie referred to that when the prosecutors are supposed to be in front of a particular judge all the time. Unfortunately, I work in the community, not unfortunately that I work in the community prosecution unit, but what's happened is we have judges who have civil and criminal cases, and I think that we probably need to dedicate some of our resources, if we're going to block cases, to just have judges listening to the property drug cases like what I prosecute, judges that strictly do some of the misdemeanors, judges that strictly do some of the civil cases, and then mix it up when they need to so that people aren't in the same area all the time. I think that there needs to be more efficient blocking of cases.
What do you perceive as the greatest obstacles to justice, if there are any? And the first responder would be Stephen Antolak.
I would say right now, the easiest one to point at is shrinking budgets. There are fewer and fewer court personnel around. I mean, I remember days when there were plenty of personnel around that could move files around. If you needed to, you could find other judges because there were staff that available, court reporters, all kinds of things like that. I think that's the real challenge right now, because if we get too far ahead of ourselves on some of the scheduling and some of the blocking and things like that, we prevent access from other people to the court system. People who perhaps aren't as adept at moving through the system, people who aren't there on a regular basis, and that's an access to justice issue. So we need to make sure that we are open to people who don't have the kind of access that we need in times of these shrinking budgets. And we just need to make sure that we're thinking through these steps as we go forward.
Elizabeth Cutter.
Could you repeat the question? What is the greatest challenge to access to justice?
What do you perceive as the greatest obstacles to justice?
I think that Steve is right when he talks about resources. I think that we need to be able to do the job that we have always done with fewer resources. We need to, the demographics are such that in the near future there will be more elderly people than there are school-age people, and we're going to be shifting resources to age-based services, and we won't. And that money's going to come away from the court. So we do need to we need to figure out more efficient ways to deliver those court services that we've always delivered more efficiently and cost-effectively. I do think that cost is a barrier. I think that cost prevents people from bringing suits and from being effective when they do, being able to hire counsel. So I do think that resources the limiting of resources is a barrier.
Diane Krenz.
I'm going to expand a little bit about what Steve talked about, because I think that funding of the courts is has become more limited, but it not only affects the number of judges and the judges' staff and court reporters, it's also affecting probation. One of the biggest issues I see is that people who are put on felony probation for property crimes don't have a probation officer. They don't do pre-sentence investigations before sentencing. There's a lot of things that are being affected that affect the court system outside of just not enough judges or not enough staff. So not enough probation officers, prosecutors, and public defenders. That's a big problem, and that's an obstacle to getting cases taken care of timely for defendants, plaintiffs, and victims.
Deborah Russell.
And I am going to agree with everybody that the lack of money is a problem, and I'll expand this even to the early intervention, the juvenile court system with child protection and juvenile delinquency. When I prosecuted juveniles in the late 90s, it was amazing how many different treatment options were out there for kids, depending on their specific mental health needs or correctional needs. And so much of that has dried up because of the lack of funding. And I think that the juvenile court judges are their hands are so tied in terms of what they can do with intervening with these children. And that goes even further back to the child protection system, because so many of the children that are in the child protection system ultimately transfer into the juvenile delinquency system, and if we can't stop it there, then they're into our adult felon possession where the adult felon, they commit felonies, and that's where the three of us see them. And so that intervention at that early stage for children, to me, is imperative.
Last question. I thought, what will we do for this last one? And you have brought which one I want to use here based on your last answers. It's 3 questions all in one, but you will roll this together. Is it appropriate to impose more restrictions on what cases go to trial? Is there a need for more mandatory mediation and settlement efforts? What would you propose? It does seem to me that this has some connection with the way that a lot of you answered the last question. Would you like me to repeat it?
Sure.
Is it appropriate to impose more restrictions on what cases go to trial? Is there a need for more mandatory mediation and settlement efforts? What would you propose? In 1 minute, Elizabeth Cutter.
Well, the civil bar did ask for and receive ADR, Alternative Dispute Resolution Services. The litigants pay for it. But I have heard recently from civil lawyers that they aren't particularly pleased with that they feel that because they have to pay for it, it's an added expense when what they really want is a trial. So I think that those mediation arbitration services have been made available. It's important to realize, too, that approximately 25 to 33% of the cases of the filings in Hennepin County are civil. The remaining are criminal. So restricting access to trials in a criminal case is not constitutionally possible. In a civil case, I think that the expense of trial is self-limiting. And that I don't know how it would be due process to limit.
Your time is up.
Okay.
1 minute to answer a question like that. Diane Krenz.
Well, I agree with Liz. I mean, a defendant has an absolute right to go to trial no matter what the evidence is against him or her. And so we cannot limit criminal trials. You know, as far as civil trials go, I think those people who have civil cases have the right to have their cases heard as well. If people are being required to pay for alternative remediation or mediation, whatever, I don't know that we can provide that for free, because that again becomes a burden on the justice system. And so maybe there is more mandatory mediation for certain types of cases, and the lawyers are just going to have to pay for it, and the participants are going to have to pay for it instead of taking it up to go to trial.
Deborah Russell.
As my two colleagues have said, you cannot restrict criminal trials because it is a defendant's constitutional right to go to trial. And as far as the civil side and mandatory mediation, it does, in theory, sound like a really great idea. But as Liz has said, the litigants in those situations are not always finding them to be satisfactory. But that doesn't mean it's something that should be given up entirely. I'm sure that it's something that could be looked at and perhaps tweaked as far as how much it would cost and in what situations it would become mandatory. Again, I think that if the bench as a whole is willing to be flexible and look at these things and try to make changes, if some changes might help the situation and help streamline some of these cases, I think that is worth taking a look at.
Stephen Antolak.
Philosophically, I'm opposed to limiting the right to trial because we diminish the role of the judiciary in our government. And the Founding Fathers established it as a co-equal branch of the government, and we need to respect that as part of our democratic system. But aside from those constitutional issues, there are things we can do to aid the system. I mean, in federal court, we have Rule 26F that gets rid of all kinds of discovery issues, forces people to disclose things, saves a lot of money up front and moving forward. In family court in Hennepin County, some years ago, they started an early neutral evaluation system to try and move cases along almost as like a triage method to try and resolve those cases that you can early. I was one of the guys that wasn't real happy about that because it seemed like another extra step for my clients. But it turned out that it was very, very useful in a lot of cases. So there are things we can do that don't infringe on the right to trial, either civil or criminal, but can still move along and create some efficiencies. And we need to do that while still respecting that autonomy that the judiciary has to have.
And 1 minute for a closing statement. And it's up to you what you would like to add at this point. Deborah Russell.
Thank you. I think over the years, my experience both as a prosecutor and as a defense attorney and as a lawyer in the Army Reserves providing legal assistance to active duty soldiers as well as reservists has given me a really broad perspective, and I think that's what's needed with a judge. A judge needs to be able to see all sides, to listen to all sides, and to have the reputation of being a fair and impartial neutral fact finder. And I think my reputation in Hennepin County is that of a fair and reasonable prosecutor. I have a lot of support from defense attorneys. I have worked in the child protection section as well as juvenile prosecution. I recognize the importance of court intervention early in a child's life and throughout their life. And I do think that my qualifications and experience would make me a fair and respectful judge. Thank you.
Candidates did draw for a position in this. Elizabeth Cutter is the second.
Thank you. I again invite you to go to my website. My literature is on the table. My website is www.cutter4judge.com. My experience as a civil and criminal trial lawyer, I have tried over 100 jury trials and literally hundreds of bench trials, trials without a jury. I have management experience. I have been involved in my community throughout my life. Again, the list of community activities I have is on my website, but I have had leadership positions in those community activities. I have the support of people I have worked with, both as opposing counsel as well as people in my community activities. I am honored to have the support of both community and legal leaders. I believe that my experience, my background, my temperament all suit me well to be an excellent member of the Hennepin County Bench, and I hope that you will vote for me on
Diane,
August 14th.
Diane Krenz.
Now that Liz has provided us with the number that 75% of those 800,000 cases in Hennepin County are criminal cases, I think the strength that I bring to being a judge is the fact that I have tried over 75 jury trials, felony jury trials, very serious cases, done gang cases, dealt with gang members as witnesses and victims, dealt with people who have been assaulted and raped. And I think that my experience is that I can step on the bench immediately and begin handling those very serious cases, handle all of those criminal-type cases. I think every single person on this panel has people from both sides supporting them, has community leaders supporting them, and I'd ask you just to look at the experience that I have.
Stephen Antolak.
I've been a lawyer for almost 30 years, and I have a great breadth of experience in the substance of the law as well as the procedures and the kinds of things that make up trial work. I've run law firms before. I've been the CEO of a small fraternal insurance company. I've done a lot of those management things that help companies move forward. It's all about being resilient. It's all about being entrepreneurial. It's about finding new ways to do old tasks. And the one thing that I have learned going from court to court around the state, around the country, is that one voice on the bench can make a big difference. You get into those staff meetings, you get into those meetings, and you can create new ways to pursue justice, to bring justice to the people that are needful of that in our society. And that's the kind of thing that I can bring. I've been trying cases, any one of us up here can get up and try a case. It'd be a great show for any of us to do it because we're all good at it. But I need to bring something more than that, and that is some management experience, some new ideas on how to improve the system.
And we thank Northwest Cable TV for broadcasting this tonight, and Gloria Erickson of the Golden Valley League of Women Voters is going to tell when this is going to be played more times.
Yes. On behalf of the League of Women Voters of Golden Valley, I would like to thank our candidates for being here tonight, and a special thank you to Kay McCauley for being our moderator. In advance, I would like to thank Minneapolis Television Network for their replay of this program. We hope this forum has helped the audience here and at home to make an informed decision. Also, I would like to thank Northwest Community Television for making it possible to view this at home. And the replay dates on Channel 12 are as follows: Saturday, July 28th at 6 p.m. and Sunday, July 29th at 6:30 p.m. We would like you to join us tomorrow night at 7 p.m., July 26th, for the Hennepin County Commissioners District 2 Forum. And this will be televised live on Channel 16 in Golden Valley. If you are interested in learning more about League of Women Voters, there are brochures on the table in the hall, and League members will be happy to discuss League activities with you. We would love to have you join us. I would like all of you to stay for refreshments and conversation with the candidates. And above all, please remember to vote Tuesday, August 14th. And I would like a very warm round of applause for our candidates here.